so that he can perform the pursuit instead of us.
Excellent. Thank you. When you broke off from the chase and returned to the original incident, what was the status of your vehicle?
Status of the vehicle was that it was operational.
Was the vehicle smoking at this point?
The vehicle was smoking.
Right. And uh, based on your experience with CVPIs and them being damaged in the line of duty, uh, did you believe that it was safe to drive the vehicle?
Objection of a
Based
layperson.
on my experience and training, yes, the vehicle was safe enough to transport the individual, Michael Banks, to MRPD.
Oh, holy shit! If you say that and it blew up, that means you need to be retrained then. Fuck!
Ever had a vehicle that was smoking catch on fire or explode before?
I have personally never
Objection, Your
experienced a
Honor.
vehicle explode.
Relevance. And he answered while I was objecting.
What's the objection?
To relevance, Your Honor.
Can you expand on that for me, please?
Yeah, I mean, I'm not. Well, I could also object to, this person not being an expert witness in mechanics unless they're trying to certify him as such.
Yes.
But I mean, I'm not sure why, if a car ever blew up on him before.
Now, if I was Monroe, I'd be pushing on what kind of fucking experience he has with vehicles and what training he actually has. Now that they brought that into it.
The plaintiff is proposing that the officers did not take proper care and custody of the suspect. I think that if the officers were unable to foresee this consequence, then it bears relevance.
I also find that the large amount of the case that the plaintiff is presenting here today is based on this observation that the vehicle was smoking, being spoken to by the plaintiff as a reason that it could explode. I do find that this is relevant with the claim that's being pressed. Objection is going to be overruled.
Right. Thank you, Your Honor. Officer Troy, do you need me to repeat the question?
Please repeat the question.
Have you ever had a CVPI catch fire or explode on you before?
I have personally never witnessed a CVPI explode.
Right. Have you driven a smoking CVPI before prior to this incident?
That is correct. Yes.
I'm sorry, just a second.
Monroe.
Were you able to observe any of Mr. Manx's injuries?
One Reggie doesn't like.
Of the explosion.
I myself was injured from my periphery. He suffered the same injuries that I had.
All right. And what injuries were those?
Minor burns, some concussive damage. The doctor told me my big toe was cut, so I'm not too happy about that either.
Ain't no way that they just let him say the same injuries as me without objecting to that. He's not a fucking expert with that shit. He's not a medical fucking professional. Why would he know what his injuries were?
Thank you for bearing with me. One final question on direct for you. Officer Troy, how long did it take for your injuries to heal?
Ain't no way.
Your Honor, we find it extremely relevant. The plaintiff is here in court today asking for monetary compensation for pain and suffering.
Yeah, his injuries, not the officers.
We would just like to have a comparison.
Ain't no way.
Your Honor, if the rebuttal
I'm
to that
inclined. I'm inclined to sustain the objection here. Look, two different people may heal from injuries in two different manners and capacities.
Yep.
I don't think this is an apt comparison to make in this case.
Yep.
To put it simply, individuals recover differently from injuries in different ways. I don't think this witness's recovery time compared against Mr. Manx's is particularly relevant.
Yep.
All right, thank you for your ruling, Your Honor. No further questions on direct for this witness.
Okay. The floor is going to be open for cross, but I will need to place the court in a brief 2-ish minute recess. I just have a matter I need to handle personally. Give me just a moment, okay?
Understood, Your Honor.
Mhm.
Yeah, I don't have shit. I don't have the same as you, bro.
Just a quick recess.
This is what 3.5 hours feels like, by the way.
Oh, you can't leave the witness stand.
You're
Get
on
back
the
up there.
stand. What did
You cannot talk to other people. You must stay on the stand.
Get back up
Do
there.
not, do not leave the
Come
stand.
with me. We'd have to go out. I got to.
I'm
Your
on the
bailiff
stand,
instructs
Mr.
you to stay here.
All right,
Alright,
bailiff.
great.
All right, relax. I'm here.
Are
All
you
you
good?
had to do is tell me once.
Hey, I'm calm. Don't tell me to
All
relax
you had to
there,
do is
guy.
tell me once. I'm a
You're gonna
very
fire me up if you
aptitude
tell an
person.
Irish lass to relax. When I was
Okay.
calm, what
Alright.
part of me did not
You didn't
seem
sound too calm to me.
Now I'm hype.
All
Can
right,
y'all
bring it
calm
on.
Siobhan, your
down,
Irish is
please?
showing.
Do you need a potato or something, Siobhan? Just kind of relax.
She actually just broke a glass in my room. Oh wait,
Aim for his toe.
In your
Siobhan.
what?
Aim for his
What?
toe.
nobody
Don't
heard
go for my
that.
toe.
In your what?
Nobody
What?
heard that.
you learning anything?
I think he meant his glasses in this
I have a
room.
lot of
Oh my
notes.
God.
That makes sense.
Fucking -1.
I got some potato chips, Siobhan.
I'm
Can I
dead.
help you?
I'm gonna just throw this out that.
See you on Red Lapel.
We'll talk
This is
after.
Women's Month.
Yep. Told you.
Crazy thing, by the way. Just throwing
Crazy,
this out there.
Jasmine. Crazy.
Just if
I
for
don't
going on and let
participate
people know
in Women's
the
Month.
metal
What?
detectors did not take my food today.
Fucking took mine.
Wait, do the metal detectors take food?
Yes.
Yes.
Can we
Everybody else?
boycott the metal detectors?
Yes.
Yes.
Jesus Christ.
I have guns in the courtroom than not have
That's right,
food.
bro. It's. I'm telling you, it's big energy bars because they fucking.
Form of potato is potato juice, also known as vodka. Thank you.
You've never had potato water? Potato water's great.
Let's go get some food. Some chip.
All right. Yeah, sounds good.
What the fuck is potato water? You just soak a potato in
Content
water?
of your brain.
Ew.
I'm still cooking.
What'd you think?
Hello. I didn't see it all right. But
Me neither.
one thing I do think on the last line of questioning was he brought up his training and expertise as a police officer and how the vehicles are used, right? So then what that then does is it now leaves it open for the claimant to stand there and question his training and how long he's been trained for that, and then harp on that. And if it is the fact that he's been putting people into smoking vehicles, then maybe he should be retrained if a captain is standing there stating that they would not do that. So which one is it? Was he trained correctly or was the captain incorrect?
Yeah.
That's the route that I would go to really fucking turn him down on the stand.
I feel like this is a lot about semantics, you know?
It is,
Small
yeah.
points.
Apologies. We should be good to proceed at this time.
Shit, bro.
Floor is open for cross-examination for the witness.
I didn't ask any questions, right? No, I didn't. Okay, we're good. All right, I got this. All right. Logging. How we doing, Mr. Troy?
Who the fuck
I'm
just
doing
said law
fantastic,
gang?
Miss Monroe. How you doing?
Doing all right. Doing all right. You were in the car when you were in the car when it was being driven while it was smoking.
I was the driver of the vehicle. Yes, sir.
What color was the smoke coming out of it?
It was a dark smoke.
all these other times you've driven around, you drive around normally with dark smoke and coming out your vehicle?
Can you restate the question or rephrase
Yeah,
the question,
so
sir?
During your earlier testimony, you mentioned you drive vehicles. I don't want to say regularly, but you drive vehicles when they're smoking.
Yes,
correct?
I have experience driving CVPIs whilst they're smoking.
Okay, and in those situations, are they usually billowing out black smoke?
Dark smoke, yes.
Okay. And my client warned you that he thought that there was going to be an explosion in that car?
The only warning that
Objection,
he...
is there a question in there?
Doesn't need to be a question. It can be leading.
My client warned you that there's going to be an explosion in that car?
I didn't quite hear the word "did" come from either, counselor.
Yes, I didn't either.
Might
That
be
was my
fault
objection.
there. I apologize. I meant to say did if I didn't. Yeah,
All right, then withdrawn.
take my
Thank you.
lickings.
Okay. We'll add that on and we'll call it a question.
Sure. Could you answer the question?
Can you restate the question?
Yeah.
Did my client warn you that he thought there was going to be an explosion?
There was 2 mentions of smoke from the vehicle. There was no mention of an explosion.
Okay. Did my client seem like he was scared about this?
He expressed
Objection,
concern.
speculation.
As an officer, you should be telling whether or not someone
Depending on
feels
how
scared.
you viewed my client's state of mind. Officers do this all the time.
Yep. Yep.
I'll defer to your judgment, Your Honor.
I'll allow the officer to refer to his direct observation of the witness and what he interpreted, but, he's not him, that whole deal. You've
course.
heard me say this countless times. I'll allow the general understanding of the assumption, or not assumption, but his understanding of the situation to be read into the record. You may answer the question.
Qualified police officers should be able to tell the general demeanor of a person.
Did my client seem scared?
Your client did not seem scared.
Okay.
Did that car eventually blow up?
The car eventually blew up. Yes.
Was my client injured in that explosion?
Your client was injured in that explosion.
Were others injured in that explosion?
Others were injured in that explosion.
And why was it that you were the one transporting my client?
We were ordered to transport your client to MRPD for processing.
Why?
Objection, speculation.
How would it be speculation?
If he knows the answer, he can answer. If he doesn't, he can say, I don't know. I'm not asking for speculation.
Let's rephrase that question to "Do you know why?" then, rather than just "Why."
Do you
Objection's
know
going to be
why?
sustained.
Do you know why you were instructed to take my client to MRPD?
Yes, I know why.
Okay, can you elaborate?
We were instructed to switch positions with Officer Matt Rhodes, because his vehicle was in pursuit condition. Our vehicle was not in pursuit condition.
So your vehicle wasn't in pursuit condition, but it was in condition to transport someone in your care and custody.
That's correct.
Ask what the difference is between pursuit
Are you
condition.
responsible for the protection of the people in your care and custody?
I am responsible.
Ask what pursuit condition is.
Take care of my client?
In good faith and to the best of my ability. Yes, I do.
Are you an expert mechanic?
I am not an expert mechanic.
But you repaired the car that eventually blew up, right?
Objection, argumentative, and asked and answered.
I don't think it's argumentative personally, but
Ain't no way.
I'm asking the question because there was mention.
Ain't no way he's asking about that.
You stated that he was not the mechanic. I'm just clarifying that he repaired the car shortly before it blew up.
been testified that he utilized a repair kit after the collision. It's also been testified that the vehicle was properly repaired at a mechanic shop before they arrived at Legion Square before the incident that occurred. That's a point of order we can read out for the record, and we can move on from the question, sir. I don't need to retread. I don't need the retread.
How do you know that you're prepared and do more harm than good?
I'm sorry, sir. Can you re-ask the question again?
How do you know that you're repaired and do more harm than good?
Objection relevance?
An unqualified mechanic repairs a car shortly before it blows up, and that's not relevant?
Your Honor, can I rebut
I
that,
think
please?
we're gonna move on from this that particular question as
No worries.
strange.
No further questions.
You get my drift.
I got you. No worries.
All right, perfect. Fantastic.
Redirect.
Who keeps yelling at Law Gang?
Your Honor, we have no questions for redirect. Thank you.
Who keeps yelling out Law Gang?
Go ahead and step down this time.
Oh, thank you very much, Your Honor.
Hey, any additional witnesses or evidence you'd like to highlight at this?
Yes, Your Honor. Thank you.
Sure.
We would like to highlight the Plaintiff's Exhibit A, the medical report for the plaintiff, in which the doctor expresses that the injuries were first degree and that the individual had no issue.
I thought it sounded like Moose Knuckles.
Being able to speak, and
I don't see him.
was very vocal during the procedure. We would like to then highlight officer testimony, both Fields and Troy, where they quote that the witness or that the plaintiff was speaking about suing them and getting rich. And we would like to point out that the vehicle was according to their testimony, in top repair at the beginning of their shift. And this was basically their first call, responding after the vehicle repair. Thank you.
I'm curious as to why mentioning his first degree burns and him being able to talk
Is the defense rest?
is anything to do with
Yes, Your Honor, the defense.
pointing out evidence, because
How are we looking with closing
the
statements?
first degree burns could be anywhere,
Go,
right?
Your Honor.
Ready to go.
Fantastic. Let's hear them.
We better do, CVPI that's smoking an officer doesn't know how to fucking drive.
As this case draws to a close, we must reflect on the principles that underpin our justice system and the responsibilities of those who uphold it. Qualified immunity generally exists to protect officers from harassment, distraction, and liability when they perform their duties reasonably. While I'm not convinced that qualified immunity exists in our jurisdiction, given its lack of existence in the Constitution, if you find that it does apply, then we would ask that the court realize that the warnings made to the officers show a willful neglect of listening to my client as he proceeded to be harmed while in their care and custody. Qualified immunity is not a shield for willful negligence, for ignoring clear and present dangers, or for failing to protect those in their care. In this case, Michael Manx, the very people he relied on for safety, became the agents of harm, whether intended or not. This, Your Honor, is precisely where qualified immunity must be scrutinized with rigor, should you find that it exists. The officers, despite being alerted to a critical risk, chose to disregard that potential catastrophe. That potential catastrophe turned into an actual catastrophe where all of them, including a bystander, were injured. That decision was conscious and shows deliberate neglect of a duty for care, directly resulted in the harm that befell my client.
I'm curious if Norman states that qualified immunity is there.
The
I'm curious.
police have brought up, or the police's defense, excuse me, have brought up on multiple occasions that my client mentioned how he was going to sue them, how he was going to be rich, and all of this. I ask you, does the police department prefer that my client resort to criminal action to get redress for his injuries? If not, then what other choice does he have but to come to this court and ask for redress? Threatening to sue is within his legal right, given the things that they did to him. He is entitled to damages for pain and suffering, and these officers and the police department should be punished for their negligence in this matter. We respectfully ask that this court consider the evidence presented, the testimonies that we heard here, and the law. We ask that you hold these officers accountable for their actions, and you affirm that no one, including officers, is above the law, and ensure that Mr. Manx receives the justice that he so rightly deserves. Thank you.
Law gang.
Say that one more time. I'm giving you contempt.
Understood.
Oh, Damien.
Defense, you're closing.
Thank you, Your Honor. And for your convenience, I have emailed you a copy of my closing.
It's Damien.
Your Honor, ladies and gentlemen of the court, while the events described here today by both sides of the aisle are unfortunate, they do not provide. I'm sorry, just a second. I don't know. Apologies, Your Honor. May I start over?
She sounds so nervous. The poor thing.
Your Honor, ladies and gentlemen of the court, while the events described here today by both sides of the aisle are unfortunate, they do not prove negligence on the part of my clients. They made sure their vehicle was in tip-top shape at the start of their shift and used repair kits when damage to the vehicle occurred. All of the officers who testified today, including the plaintiff's witness, Captain Slacks, have experienced driving CVPIs in various states of disrepair and had no expectation that the damaged vehicle would explode. Even the expert mechanic who testified today under oath agreed that the explosion was not the inevitable conclusion for a smoking vehicle. Officers Fields and Troy were ordered to head back to the city
We
to
apply
get
for
the
lawyer
vehicle
now.
repaired and the plaintiff to MRT.
Oh no. I have no desire for it.
Despite the opportunity to flee the burning vehicle and save themselves, they attempted and succeeded in getting their suspect out of the vehicle, operating in good faith regarding the welfare of Mr. Manx. Therefore, we ask the court to find my clients not liable for the injuries sustained by all parties in this tragic accident. Thank you.
Okay. I've got actually quite a bit to think about here, pertaining to this matter. I'm going to be placing this court into recess while I go to deliberate. I'm expecting I'll need maybe 20 to 25 minutes or so. You know, you guys have free range of movement. Try to be back in the courtroom in that time frame. In case you need to go get food, drink, anything like that. Court is in recess until such time.
Thank you, Your Honor.
Thank you, Your Honor.
All right, not that I'm complaining, but it's been 3.5 hours. This is what 3.5 hours feels like.
What is what the fuck
Needs to get a new bit.
CBP?
I don't know. Just saying it every time, and actually, it's been longer than that, but it is what it is.
I mean, bro, listen, like, you know, the facts that I was in there for 3.5 hours.
I mean, Rhodes is.
Stop it!
What?
Where'd you go?
Over here.
Take me with you. I want to know what you're thinking on this. I'm curious.
Take
me with you. Talk it out.
Okay, I gotta go downstairs and get my shit because I forgot to sign back.
Okay.
I'll use the head of our office.
Okay.
Head in here.
I'll wait here. Yes. Get the thoughts on this. I am so curious on what the whole qualified immunity is. I got in. We're not going to try and sway him. I'm curious as what his thoughts are. Because Norman will say through Reggie's bullshit of trying to sway. Reggie has no vested interest in this.
Sorry, we'll find another place to talk.
Okay. I am so curious about this.
This whole thing's fucked.
So a part of it, right? You've got to work out qualified immunity. Have you guys decided on that yet?
No.
Oh, so this could be
No.
breaking towards. Put you in a shit position.
Well, I think I'm already determined that I'm going to go with the more simple answer here, and leave the concept of qualified immunity up to the larger courts. I think that's probably not a concept I need to consider. That's probably more left to the council as to how we address that going forward, since they are dipping their hands into everything else, right?
Well, I mean, previously, as you know, civil case never really gave us any kind of legislation, right? Or case law on its own.
Yeah, it does now.
So it's a shitty position that you're in on whether or not you look for that qualified immunity. So while still putting it in the hands of others to determine, there's still some point that you'd have to leverage on it for this, right? Because I think that there's somewhat of an implied qualified immunity. Otherwise, police would get sued left, right, and center, right?
Yeah. So that's why kind of with this matter, I'm probably going to try to keep it as much to the facts as possible, and determine whether this individual is worthy of the amount requested or not for the grounds he has done such. On the surface, here's where I'm thinking. He's looking for $30,000 in pain and suffering damages. The medical report states that he had some minor first-degree burns that he recovered from within about a week's time. He did not receive any follow-up medical care other than the initial hospital visit.
Actually, it's been
and
longer,
he's testified that he
wasn't it?
supposedly went to go see Dr. Tanner Phillips for psychological damage on three different occasions. None of those reports were entered into evidence. There's no.
Well, then you rule
preponderance.
that out, right?
Correct.
Because if there's no
So I
supporting
have the
evidence to that, then whatever.
Correct. There's nothing to preponder the evidence. So I have that he had minor injuries at the time.
If Norman's
And that
streaming,
is
make
an
sure you guys
evidence.
show him some love, please. Jason
The
plays
thing
games.
I now have to more stick with is the establishment of duty of care, and the wrenches that have been thrown in basically at every step. Where I thought I had a clear answer to this before the last witness, there was an invocation of pursuit-ready vehicles versus non-pursuit-ready vehicles.
I was curious about
implying
that.
Implying that there is some understanding of risk, right?
I'm surprised
now-
that they didn't go in on that a bit more.
No, I think Monroe trusts me enough to go in and out on my own. Because now, conventionally speaking, you and I know that maybe an officer doesn't want to pursue with a vehicle that's already damaged, because if something were to happen, like a minor collision, they're going to lose the vehicle that they are pursuing. It is more of a risk that they are going to lose the actual suspect who is now actively committing a crime in reckless evading, right?
Yes, correct.
But it does raise the question of, wait, if it's not pursuit ready, what is it ready for? We have two mechanics that work at the same mechanic shop. One of them in Jonathan Acker saying, I would never recommend that anybody drive a smoking vehicle. There is inherent risk here and things can happen if done so. On the other hand, I have Patrick Tuna, senior mechanic, same shop, saying, yeah, if someone tells me their vehicle is smoking, I tell them to drop everything and immediately drive the vehicle to the shop to get it repaired.
They're still telling them to drive the vehicle, but
To
to
drive the vehicle, right?
Drive it to a repair shop. Yeah.
Right. Him and even going so far as to make the invocation that tow drivers are unreliable and can't be trusted. Just drive it here right away.
Hmm.
Right. So even the experts that are brought in here are completely at odds and disagree with each other.
Yeah.
I have Captain Slack stating that it's a courtesy that they shouldn't do that. It's not standard operating procedure that suspects shouldn't be placed into smoking vehicles, but that there are times where it appears to be necessary. I have officer experience testimony stating, I've driven smoking cars hundreds of times, and it's only ever exploded once. I have the one expert mechanic saying, I've seen hundreds of smoking vehicles. I've only ever seen 3 explode. A 3% chance is still a 3% chance.
Yeah.
You know,
Daddy, don't thank you for the 2 years.
You know, there's no clear answer here right away.
No. I mean, one thing you can rule out, right, or help with the any kind of money that they're requesting, right, is looking at the medical side of itself, right? So you stated you got the medical report. There was no follow-ups done. However, there were first-degree burns involved, which you're curious as to why there wasn't further, like medical checkups, and then why did they not submit the psychological reports?
Yeah. Now, Tanner Phillips was originally called as witness to the matter, but then there were multiple witnesses called by the plaintiff. We have the 2 at trial limit. He elected to cut it down to Captain Slacks and Jonathan Acker as mechanic to speak to the integrity of the vehicle.
Why would you not keep the psych that will help you with the monetary gain of this? Like, okay.
Or I don't know, at that point, try and get the reports.
Yes, 100%.
Or a deposition or something.
100%. So looking at money-wise, is 30K valid for the one medical report that's been given?
No, I've come so far as to decide that at least already. Negligence and duty of care is where I'm stuck. And thinking still.
Which comes into play,
yes.
qualified immunity, and then whether or not there was a risk, but putting them in that vehicle, you've got the captain stating that they wouldn't put someone in a smoking vehicle and transport them, and you've got the person who did it saying that they've done it before and drive it around, and you've got a mechanic stating two mechanics stating 2 different things. You're in a fucking shit spot with that.
Yeah. Well, and then the captain further clarified and said, hey, it's I wouldn't do it. It's not standard operating procedure, but I wouldn't do it as courtesy.
Yeah, I mean, it's interesting that you say that. However, the final witness stated that with their training and expertise as an officer, they've done it plenty of times, right? So yep. Is it training and just not an SOP?
No. His statement was that he's driven a smoking CVPI hundreds of times.
Yeah, but he said something about
he's placed suspects into them.
He said something about his experience with smoking vehicles, training and experience. I can't remember the exact wording, which I found very curious, and I wanted.
Based on your personal experience, did you believe that a smoking CVPI was safe to drive? He answered, based on experience and training, yes, it was safe to transport to Mission Row PD. And then it was further asked, have you ever had a smoking vehicle catch on fire? He said, I personally have not. Have you ever driven a smoking CVPI before? Yes, I have. Officer Troy he towed the line basically perfectly, right?
Yeah.
He walked the tightrope and he made it across.
But you could tell the way that he was answering in a way to not
he was ready Whereas I had to remind Captain Slacks that he was summoned by the plaintiff. Because he immediately walked in the courtroom and went to go stand behind the defense table. And I was like, nah, buddy, you're on the other side.
Right, so everything aside, did they fail the duty of care with the suspect by placing them inside of a vehicle that eventually blew up? Is the main question.
And I think with what's been given to me, I think the answer is no. Because again, here's the other bit that Troy testified to, right? He said on the way up to where this traffic stop was taking place, we had a head-on collision with a local. The vehicle was disabled, and I applied a repair kit. We go back to the witness that testified pertaining to him not recommending to drive a smoking vehicle, right? Go back to him. To Jonathan Acker. It was asked, you stated that you don't recommend operating a smoking vehicle. Yes, that's correct. How would you recommend that they get it repaired? His first answer was, quote, you could utilize the toolkit to perform first aid maintenance on the car, i.e. repair a fuel line or damaged component, maybe add additional coolants or lubricants in order to get the vehicle to an operational state. So he's stating that
which is what they
that
did.
the officer took is yes.
See, then I'm curious as the fact of why it was still smoking after they had done that.
Yep. And you know what nobody brought me? Any evidence of the initial repair or any evidence of a repair that may have occurred after the fact.
Which would have helped strengthen PD's side. So now you're just taking
either side. It's now just what people said that they saw.
That's he said, she said kind of deal. However, someone was injured during said he said, she said.
Yeah. That may be the out here, though. Is yes, an explosion, a spontaneous combustion did in fact occur. There is some merit to the debate over the state of the vehicle. There is conflicting testimony from both expert witnesses and officers as to what should have been done in that instance. This clearly has not been firmly established. As it has not been firmly established, I don't know that I can assign fault to the officers in question. But I do strongly recommend that the department review internal policy as to how to ensure this doesn't happen going forward.
Now, then that leaves the question of do you still award some money due to the injuries that happened?
No, because under the under legislative purposes, where the hell is it? Under the Bill of Human Privileges, all citizens of Los Santos are eligible for free health care from all public hospitals and medical facilities. There's no cost.
However, there is cost to psych. Now, he didn't provide that he paid anything for that.
This includes mental health services, too, that are under the Los Angeles Medical Group and not privatized.
That's very interesting because I spoke with Pixie the other day saying how they're not paid by the state, so they have to ask for money from the people that they see. Interesting.
It is not illegal for medical workers to accept tips and or donations.
It's not illegal, or it is illegal?
It is not.
Yeah.
Section 2 of this lovely Bill of Human Privilege.
So if they just mask as a tip, then that's not a payment, thus meaning he wouldn't get repaid for it. Holy fuck! All right.
Correct. Yep. Yeah. This kind of fucks this guy hard.
Yeah. Because he's not paid anything out of pocket for that, but the suffering side of it.
And he hasn't articulated the suffering.
Correct. Yes.
I woke up with some minor inconveniences to a first-degree burn.
And the suffering could have come in the form of the psych reports, but they didn't put those. Holy, they fucked themselves. Why would they not put the psych reports in there? That's just dumb. I have never understood people that go after police for money without having supporting evidence for the damages that it's caused that are ongoing. It's crazy. Because that's the whole point of your case, right? It's not about the immediate that happened. It's about the ongoing that's happened. Oh. I mean, you're gonna be a dickhead either way. It's a judge life, right? Whatever way you rule, but I can understand what you're saying for that. Like, there was a lot of things that the claimant didn't put in there to do with the medical side of it. So why are you seeking a large sum of $30,000 without supporting evidence for that, regardless of the fact that there's 2 witnesses that you can have? There are other alternate things you could have done. Like, for example, put the actual reports in there and have them sealed if you don't want people in the public to see them.
Yeah. I gotta cook what I'm gonna write here, so I'm probably gonna sit here in silence. I don't know
yeah.
if you want to sit here while I sit here in silence.
I'm gonna stay
wanna-
here so no one tries to fucking question me. I'm gonna stand over here. You do your thing.
Okay.
Yep. I agree with Normal with that. Right? And I said it like in character, right? Is if you're going after people for these medical fees, right? One, healthcare's free in Los Santos, so you've always got to bank on something else that you need that's not inclusive of the free, right? And then what that would be on that is coming down to the fact of psychological stuff. So proving that you're having issues that are not something that normal healthcare have fixed yet. So it's now affecting your day-to-day life, which is where the issues can lie there, right? And then that's what helps secure that money. Is yes, the medical report here says that he's having sleepless nights, that is not motivated to go out there and do things. Anytime he sees a police car, he cowers. Shit like that, right? Then that is the suffering part of it, right? The doctor's stating that he's now walking forever with a limp. That's the pain side of it, right? That's where you put those things in. And secure that money that you're going after. You can't just sit there and say, yeah, well, this happened. Give money. You need to support that. So that's the frustrating thing that lawyers in NoPixel have forever messed up. Is they're not giving the supporting documents to do those things. That was something that just blows me away that people don't do. You're asking for $30,000. It's you need to back that shit up. So I think that's a ball drop on the claimant side. That has pretty much fucked his case there, which we'll explain to KJ afterwards about. Is they should have had reports in there. If they didn't have reports in there, then that's an issue. The punitive damages for the $20,000. People in Los Santos drive a smoking car all the time, right? Reggie's had his car blown up once. And now he's forever checking his car to make sure that doesn't happen again. Reggie doesn't like driving smoking cars and fixes them straight away. So to fix it and then transport someone in a smoking car is silly. If you have had one explode before. If you haven't experienced that, then it's something out of the ordinary for you. It's not fixed for a while. Every time it got repaired, a repair kit, it starts smoking again. So if it's something that's out of the norm for someone, right? Something that's not ordinary, and they have smoking cars a lot, I can understand the point of it not being on them. But my question then was like what we asked Norman is, why after you repaired it was it still smoking? Did you repair it fully? Like, what happened there? So to me, that should have been pushed on more as to why the car had been hit with a repair kit, yet still driven to where the suspect is. Load the suspect up because you're told that you're to swap out because you're not pursuit ready. Then to transport the character, the suspect, right? Why was it not repaired to a point where it was no longer smoking before putting someone else inside their vehicle? But they didn't ask those things. I'm banking on the judge to look at that and say, okay, well, yeah, I get why they didn't. Kind of deal, and it was fine. It's hard. Because yes, the judge will understand that, but there needs to be more into it. And why? Did you hit something else to make it smoke again? Did you only half repair it because your repair kit ran out? Like, what happened there? And then if it was the fact that they used a repair kit but it wasn't enough to fix it and stop it from smoking, that's an issue then. Did you not ask someone else to bring you a repair kit so you could help with the car or get a car that was no longer smoking to transport the suspect? And if not, why did you not? Vaping is for losers. Fuck off. I can tell you now, KJ is going to be upsetty spaghetti after this. KJ will be upsetty spaghetti. I'll be like, fuck the DOJ shit. And Reggie's straight up going to tell him, well, this is why the lawyer kind of fucked up. This. You could have gotten something out of pain and suffering, but you provided no supporting evidence for your pain and suffering. The joys of being a judge. You're a dickhead either way that you fucking rule all the time. That I do not miss. Get your bar back, you wake. Yeah, he will. I wonder if it was also like that maybe the engine was that flogged out that even a normal repair for it is still not enough and that it needs an engine replacement. That could have been an avenue to go down to as well. To see the general quality of what the vehicle came in like. Predictions on it, we already know the decision. That's why we're in here. We got the goss. Oh, fuck. KJ gonna be mad. Since that day, the repair kits were scuffed. Oh, I see. That changes a lot of things then. Because that's nothing that can actually be fucking helped on the end of that because repair kits weren't doing shit. I don't think the repair scuffed. It was the accident that they had on the way, which means they did the repair, but the repair didn't. The repair kit didn't work because of the scuff that was happening. Right.
Yeah, I'm not sure. Like for me, when I don't do any work on a court case until a judge presides, right?
Verdict time.
Oh, he's ready.
Verdict time.
Oh, here we go. We got a verdict.
Verdict time.
Jimmy, I'll bring it back, right?
Are you ready for KJ?
Sir, with the mask,
No,
could you take off your
verdict
mask,
time.
please?
I
It's
thought he
Reggie.
said.
I told him
Yeah,
it's
it's
okay.
real.
Oh, okay.
I heard burger time.
Because of I'll speak to you privately about it if you need.
You would get the pardon.
Yeah, I would.
You would.
I would.
Always on doing your fucking job.
We'll wait for Miss.
Shut up,
Oh,
KJ.
you're off the phone.
This isn't even my fucking case.
After
I know.
careful review and consideration,
Here we
I
go.
reached a verdict. It's somewhat of a complicated matter. So let's kind of walk through it step by step here. I'd like to remind everybody that this case was brought forward pertaining to what amounts to a tort claim for Mr. Michael Mank, who unfortunately suffered injuries as a result of a vehicle explosion while in the custody of officers Fields and Troy. Now, during this matter in the courtroom today, we spent an exhaustive amount of time discussing things such as the reason for the detainment, why the detainment and/or arrest had taken so long, whether charges should be pursued for reckless endangerment if someone is operating a smoking vehicle, etc. Before we eventually looped around to the larger issue. Did officers Fields and Troy violate a duty of care in placing Mr. Manx into a vehicle that was smoking to transport him to police custody to Mission Row PD? At the root of the claim here, I'm tasked with determining whether Fields and Troy were negligent or willfully reckless in transporting Mr. Manx while the vehicle was in a state of disrepair. There appears to be some conflicting opinion across the board on this, as to whether this is safe or not. On one hand, the plaintiff brought forward a witness, mechanic Jonathan Acker, who outright stated to the court that he does not recommend driving a vehicle that is emitting smoke, whereas the defense brought forward witness Patrick Tuna, master mechanic at the same shop, who stated that he does recommend that people drive vehicles billowing black smoke to repair shops, but that they do so immediately. There's a few things in this matter that I'd like to highlight and kind of go over in detail. Whilst officers Fields and Troy were en route to respond to the initial traffic stop that led to the situation, they became involved in a traffic accident, which led to the temporary disabling of their vehicle. In that moment, Officer Troy testified that he utilized a repair kit or toolkit in the moment to render the vehicle mobile. Regardless of expertise, it was further testified by plaintiff's witness Jonathan Acker that an individual could, quote, use a toolkit to commit first aid maintenance on a car, such as to repair a fuel line, a damaged component, potentially add some additional coolants or lubricants, etc. As a reminder, this is put forward by the plaintiff's witness. Now, there is some question and ambiguity as to whether that could or should have been done again when the vehicle was smoking. Unfortunately, it does not sound like it was, and the explosion then occurred, leading to several injured parties. So this then becomes an argument of whether the officers were truly acting in good faith or whether they were negligent in their duty of care.
Which is what we discussed.
Both officers, Fields and Troy, testified that they have driven police vehicles while smoking and have utilized vehicles that were smoking for transports at such time. Captain Slacks, however, stated that he avoids doing so. However, calling it a courtesy rather than standard operating procedure. Officers testified that they had done this in the past without issue. And defense's witness, Patrick Tuna, stated that of the, quote, hundreds of smoking vehicles that he has seen in his time as a mechanic, which he stated was to be 6 to 7 years, only 3 have exploded. In addressing the requested damages, the burden in a civil court requires a preponderance of evidence. The plaintiff is seeking $30,000 for pain and suffering. Although the pain and suffering has not been quantified here before the courts in this court's opinion. The plaintiff did not receive any additional medical care beyond the initial medical treatment for first-degree burns. And while it was stated that there were 3 psychological visits with a Dr. Tanner Phillips, neither reports nor the doctor were made available to the courts for review. Therefore, the claim and cost of that care cannot properly be substantiated by this court. As a result, and given the fact that medical care in the state of San Andreas is guaranteed at no cost, courts will be denying the damages sought for pain and suffering. The plaintiff further seeks $20,000 for the negligence of the officers. At this time, with this case as presented, based on the testimony presented by both mechanics and the officers present in this room, this court is going to find that Fields and Troy were in fact acting in good faith based on their prior training and experience. Doing as instructed by a senior officer, Flop Dugong, to assist in the transport of Mr. Manx, and it relied on their prior experience to ensure the safety in doing so. This court finds that as this case has been presented to the court, this is an unfortunate accident.
Is Kung Fu molding yet?
Accounts, one in which
Is Kung Fu molding yet?
With the emergent possibility of an explosion, did their best to
Is he yelling?
render care to their best ability to avoid injury. Unfortunately, leading to their own injury and incapacitation as well. Now, that isn't to say that perhaps policy and procedure couldn't be reviewed within the department going forward. And I suggest that maybe that happened at a leadership level as to how officers maintain their vehicles.
Is he saying how shit the judge or the DOJ?
But based on what is presented here today specifically, there is not enough for me to assign fault to officers Fields or Troy in this matter. And thus the claim for the $20,000 for negligence is also going to be declined.